I talk all the time about financial powers of attorney and how they are the most important piece of your estate planning, because we're not just talking about what happens to your property when you're gone. We want you to be able to protect your money, your hard-earned savings, your property if you become incapacitated by an injury or an illness. But what happens if you have a great power of attorney, but you put your estate planning documents in a drawer and forget about it? Will your child know what to do with that document? Will anyone know how to actually use it to protect your rights, your money, and so forth? Here are the top 3 things that someone will need to know about how to use that document to protect your rights. The number 1 top thing to know is read the power of attorney. There's some legal language in there. So for example, the person making the power of attorney is the principal. The person given the authority is the agent. So the agent, let's say your child, should read the document and get a sense of what kind of authority the document gives to the child. So the one of the things that I would look for at that point if I'm the child is I want to know, when is this thing effective? Does it become effective immediately, as soon as it was signed? And therefore the child can use it right away, or does it only become effective when the parent becomes incapacitated? They will be written in very different ways, but that will be clear if you read the document. The second thing you want to do is know when to use the document. So an agent may act under a power of attorney if the principal, let's say the parent, says, hey, I need you to go and deal with the bank on this. I need you to go talk to my investment company. I need you to go deal with an insurance company. Then certainly, if assuming the power of attorney is effective, the child, as the agent, can take that document and deal with the parent's financial needs and interests. But if the parent has their capacity and does not give that kind of consent, then no agent, no child should take it upon themselves to just take the document and start spending their parents' money on things or moving money around. That's where people get into trouble. So what about if the parent becomes incapacitated? It's clear they are incapacitated and unable to look after their own financial decisions, get their bills paid, move money around for or apply for public benefits such as long-term care benefits. In that case, clearly the POA document should be drafted in a way that would allow the child to do that. The tricky situation comes up if the parent says, I can still speak for myself. I want to give my house and all my property to this person I just saw on TV asking for money. Well, if they're clearly incapacitated, but they can speak for themselves, that's a tricky gray area, and I recommend speaking with an attorney because a guardianship might be necessary there. But it's meant as a tool that may never have to be used. The agent is never obligated to act, but knowing when to act is important, and then acting in the best interests of the parent, the principal, is very important. So that brings me to number 3, best practices for an agent under a power of attorney. So you've figured out what it says, you figured out that it's time to use it. Now what do? Well, keep in mind, the most important thing here is you're spending your parents' money, you're spending the principal's money, and you have to do that for their best interest. The law takes this very seriously. When you have control over another person's property, money, and legal rights, you better be using it for their best interests. So don't commingle the parents' money with your own. Don't just start spending it on yourself. That's how people get prosecuted for a crime of elder financial exploitation, and you want to avoid that. The next best thing you want to keep in mind when it comes to best practices for using the power of attorney is keep really good records. So as long as you can show, here's how much money was in the principal's account, mom or dad's account, and then every time you spend money on mom and dad, keep receipts, and just be able to show, if anybody ever asks any questions, that every time you spent that money, it was for mom or dad's best interests. So if you don't keep those records, that's going to be a problem because you won't be able to defend that you were acting in their best interests. And if there's clearly records where you're spending it on, taking yourself out for ice cream or something like that, and your parent is incapacitated at home, well, that's going to be a problem too. So read the document and understand what it allows you to do, know when to act, and know the best practices, which are really just keeping careful records showing how you're spending the money on the principal. If you have any questions about this, please reach out. Send me an email at info@keystoneelderlaw.com. That's info@keystoneelderlaw.com. If you have any questions, if you have a power of attorney in Pennsylvania and you want to know, am I on the right track here, I'd be happy to steer you in the right direction.